you can't hear anyone talking, but at the end, after the accident, you can hear somebody laughing. What does that say about this man's character?
Tonight's case is one that sent shockwaves through Georgia's law enforcement community. A decorated police sergeant, Donnie Smith, now stands accused of vehicular homicide, reckless driving, and abandoning 2 dying victims after a high-speed chase that never should have happened. Once praised for his professionalism, Smith's career took a devastating turn the moment that chase began on I-285. Prosecutors say it wasn't just an accident, it was a complete betrayal of duty, followed by shocking behavior that stunned investigators. But Smith's defense team says he's no danger to the public, pointing to a spotless 24-year record, community ties, and a career of service. So what really happened that night? Was this a tragic lapse in judgment, or the mask finally slipping off a man trusted to uphold the law? Let's break down the courtroom battle that will determine whether this former officer deserves a second chance, or no freedom at all.
Today is October 24th, 2025. I am Judge Case Johnson. Are you Mr. Donnie Smith? All right, the inmate has indicated that he is in fact Mr. Donnie Smith. We're about to start your bond hearing. This is the bond hearing of Donnie Smith, charged in warrant number 2025 CW 56800, vehicular homicide.
We learned more about the arrest of a College Park police sergeant involved in what authorities say was an unauthorized chase. The chase last month resulted in a driver losing control and slamming into a tree, killing both people inside the SUV.
Fox Eye's Eric Perry is learning more tonight about the sergeant's actions afterward that has him facing felony charges. Eric?
Yeah, Russ, Courtney. So we've spent all day digging through those arrest warrants for College Park Police Sergeant Donnie Smith. According to that, he did not properly follow the protocols when it came to a chase. Those arrest warrants also reveal that he did not stop to render aid. He didn't call for help. In fact, they say he kept going. Now he's gone behind bars.
This is where things get complicated. At its core, this isn't just about a car crash, it's about a police sergeant who allegedly ignored the very rules meant to protect civilians. When officers break protocol during a pursuit, it's not just risky, it's illegal. That's why prosecutors filed multiple felony counts, including violation of oath and failure to render aid. Imagine being sworn to protect and serve, then driving away from a scene where 2 people just died. For many watching, that's the true betrayal here, not just the chase itself, but the silence and the cover-up that followed. What do you think? Can decades of good service outweigh a moment of fatal recklessness?
College Park Police Sergeant Donnie Smith isn't smiling for a station photo. This is his mugshot after he was booked into the Clayton County Jail. Arrest warrants say he initiated an unauthorized chase on I-285 Sunday, August 17th, resulting in a deadly crash. According to the warrants, the police chase with the Land Rover reached more than 100 miles per hour. The driver of the Land Rover crashed into a tree near the Riverdale Road exit, ejecting both people inside. The arrest warrant also alleges Sergeant Smith simply drove away and did not report the crash, or did he stop to help? Family members identify one of the crash victims as Matthew Benton. They tell me they received a phone call about the crash but didn't learn until later about the sergeant's alleged actions. Smith faces felony charges of reckless driving, violation of oath, failure to report an accident, first-degree homicide by vehicle, and hit and run resulting in death. Now, we haven't learned the identity of a second victim involved in any of this. We did reach out to College Park today for a statement. They sent us one yesterday referring us to the Clayton County District Attorney's Office. However, in those arrest warrants, they describe the sergeant's actions as reckless and negligent. Outside the headquarters of police of College Park, I'm Eric Perry, Fox 5 News.
Eric, thanks.
Only one charge on the bond calendar. He's also charged in 2025 CW 56796, reckless driving, 2025 CW 56797, public officer violation of his oath, 2025 CW 56798, failure to make a report, and 2025 CW 56799, hit and run. Representing the state is ADA Thomas. Representing the defendant is Attorney Devin Rapus. This is your motion, Attorney Rapus. And Deputy, if you would mute, please. All right, thank you.
Thank you, Your Honor.
Excuse me, Mr. Rafus. I don't think the jail is muted. Judge, do you see the jail is being muted?
I do not.
Okay, there they are.
I muted him.
All right.
Thank you, Judge. So for purposes of the bond, I believe we're just being heard for the vehicular homicide since he has bond on the other counts, if I'm not mistaken. It should just be the vehicular homicide that he doesn't have bond on.
Right. I can consider all the counts, though.
Understood. I just wanted to make sure.
All right.
So for purposes of today, I know we all understand the Ayala factors, but sometimes I just like to give like a little refresher course, if you will. So for purposes of today, I'm going to address the no significant risk of fleeing or flight, no significant risk of danger to the community or to any persons, no significant risk of committing any felonies pending trial if the court were to grant him bond, and no significant risk of intimidating any witnesses. It's obviously my burden of production. I'll meet that burden through establishing his length and character in the community, his employment status before his arrest, responding to any sort of legal process. He hasn't had any, and I'll get into that, and any prior criminal record, which he has none. The purpose of pretrial bond is to prevent punishment before conviction and to secure the appearance of the person in court for trial. Obviously, that's the main purpose, is to make sure he's going to show back up for court when he has court. The most fundamental premise in our system is that a person not ought to be punished for a criminal offense until the state demonstrates guilt beyond a reasonable doubt. And so with that being said, one of the factors is not was he caught red-handed or anything like that. Is significant risk of flight, danger, committing a felony, or intimidating witnesses. So Mr. Smith is currently 47 years old. He's lived in Georgia his entire life. He has a house and has been there for the past 24 years in College Park. He's lived in Fulton County specifically a majority of his life, but has been living at that house that he has for the past 24 years. He does have family. He has dads, sisters, brothers, uncles, cousins, and almost all of them live in Georgia. His mom, unfortunately, has passed away. His dad and the rest of his family are watching on the live stream and have been very involved and been speaking with me quite frequently about the case and getting updates on Mr. Smith's status. He does have education. He graduated from high school, Alonzo High in Atlanta, and then went to Stillman College in Alabama, where he got, I believe it's the associate's degree for the 2-year program. As Your Honor may remember from the prelim hearing we had on Wednesday, he was with the he was with the College Park Police Department for the past 14 years, where he was moved his way up to the ranks, and at the time of the incident was a sergeant, was actually about to be promoted to lieutenant at the time. So he'd been with that police department for 14 years. Before that, he was a jailer at Fulton County Jail for about 5 years, starting in 2001. So he's been in law enforcement he's essentially established it as his career and has been doing that for quite a while. I did submit some character letters to the court and provided that via email to the court and to the state. I'd just like to reference some highlights in those letters, because a lot of those letters do come from people that were working with him or know him in some capacity. And so Dr. Dwight Baker, in his character letter, said that he's had the privilege of working with Mr. Smith during his tenure as Director of Human Resources and Risk Management with the City of College Park on 3 different occasions. He was well regarded, calm demeanor, cooperative attitude, and his ability to handle challenging circumstances with professionalism and grace. He says, while the current situation is undoubtedly serious and tragic, I respectfully ask the court to consider the totality of Mr. Smith's character and service. I have known Mr. Smith, and he's not defined by this incident alone, but by decades of honorable work, respect for others, and dedication to his community. You have Mr. Robert C. Grady. He's a chief deputy. He says, while Donnie has faced a recent challenge, I believe it's important to recognize that a single moment doesn't define an entire person's character or career. He said that as a law enforcement administrator, he's witnessed firsthand Donnie's professionalism, integrity, and commitment to doing what's right. He says, I stand behind him with confidence, knowing that his future contributions will continue to be grounded in the lessons he has learned and the strong moral foundation he has always possessed. Gene Robinson goes on to say that Donnie Smith is one of the kindest, most thoughtful people that she knows. I believe this is a lieutenant. I could get the title wrong, but H. Dorsey says that he's known Mr. Smith since he began his law enforcement career with the City of College Park Police Department back in 2011. Mr. Dorsey was his field training officer and had the privilege of mentoring Mr. Smith during his early months in the profession. Over the years, Donnie's professional growth has been evident through his service in multiple divisions and his promotion to the rank of sergeant. I'm aware of the charges that Donnie was arrested for, but it's important to recognize that this incident does not define the totality of his character or service. He's deeply devoted to his family and consistently strives to be a positive influence.
Attorney Rapist, I'm sorry. I got booted off for a second. I was on your second character letter.
I'm sorry, Judge. The second one I was just referencing was a Robert C. Grady that the court has, and it just says that Donnie's faced a recent challenge and made a mistake. I believe it's important to recognize that a single moment does not define a person's entire character or entire career, that he's witnessed firsthand Donnie's professionalism, integrity, and commitment to doing what's right. He stands behind him with confidence, knowing that his future contributions will continue to be grounded in the lessons he's learned and the moral foundation he's always possessed. Next character letter is Jean Robinson. It says that Donnie Smith is one of the kindest and most thoughtful people that she knows. Next character letter is from Mr. Dorsey, and I believe his title is lieutenant, but I could be wrong. But he says that he's known Donnie Smith since he began his law enforcement career with the College Park Police Department in 2011. Mr. Dorsey was actually the field training officer for Mr. Smith and had the privilege of mentoring him during his early months in the profession. Over the years, Donnie's professional growth has been evident through his service in multiple divisions and his promotion to the rank of sergeant. He's aware of the charges that Donnie was arrested for, but again, like the other character letters, he says it's important to recognize that this incident does not define the totality of his character or service, and that he's deeply devoted to his family and continues to be a positive influence on those around him. We have a next character letters from a Colonel David Block. He's retired colonel from College Park Police Department. He says that he continues to serve part-time with College Park Police Department currently, and that he served on the hiring board that recommended Donnie for employment over 14 years ago. He says it's a decision that I've never once regretted. He says that he could speak at length about Donnie, but he's the kind of officer he would hope would respond to if he needed anything of assistance. And he said that I ask, again, like the other character letters, I ask that you consider the totality of Sergeant Smith's career. He is not a flight risk and deserves the opportunity to post a reasonable bail so he may return home and properly prepare a meaningful defense. And then finally, Judge, the last one I'll reference is from a Tiffany Thomas. She's a deputy sheriff at Fulton County Sheriff's Office. She's known him for 10 years during her
Defense is leaning hard on reputation, and it's a smart strategy. Dozens of character letters from fellow officers, superiors, and community members paint Smith as a model cop, a family man, and a pillar of integrity. It's a reminder of how complex these cases can be. One moment can unravel years of good deeds. But let's be real, glowing character letters can't erase the video evidence or the fact that 2 people are dead. The court must weigh whether a clean past should influence justice when the crime itself is so severe. Should good character mitigate consequences, or should accountability be absolute?
During his service with College Park Police Department. During his time under her supervision there, Sergeant Smith distinguished himself as a reliable and hardworking professional who took pride in his role and the responsibilities entrusted to him. He displayed exceptional leadership, mentoring junior staff and managing complex situations with sound judgment. He's a dedicated individual who's made meaningful contributions throughout his career. And again, like most of the other ones say, it's important to recognize that this single event does not define his career or his character. Just a few character letters. I told the family not to bombard me with many, but I'm sure we could have gotten many more. I've said that most of them would probably be redundant after about 5 or 6. But Judge, based on those character letters, based on the facts that I've proffered to the court with regards to Mr. Smith's history in Georgia, no prior convictions, no prior arrests, 47 years old, went his entire life serving in law enforcement, serving the community. Up until this point, we have his first arrest. And again, this is based, as you remember from the prelim, based on taking the state's theory as true and the evidence presented as true, as a policy violation for a pursuit. And then the car crashed, and that's what led to the 2 deaths. It was a quarter mile in front of Mr. Smith's patrol vehicle based on the testimony from the prelim. Based on the evidence that we have today and things that I've said, he's not a significant risk of flight. We know that. He has ties to the community here. He's got his family. He has his house that he's been here. He's served in law enforcement here for years. He poses no significant risk of threat or danger to any person or the community. I'm not sure. I would imagine the state's argument might just be that factor, that it's just a danger to the community. My position would be this happened during his role as a law enforcement officer. He's obviously not working in that capacity anymore, nor can he work in any capacity as a law enforcement officer. I doubt the state's going to say that as a civilian they expect for him to conduct high-speed pursuits of individuals with stolen vehicles. He poses no significant risk of committing any felony. These are no facts that would suggest that he's going to commit any other crimes due to the lack of history his entire life. And then, of course, no significant risk of intimidating witnesses. There are no witnesses in this case to intimidate. And so what I'm asking for, Judge, for the vehicular homicide charge, I'm asking for a $15,000 bond. Obviously, if the court wants to put that he cannot work in any sort of law enforcement capacity, that's fine. He can't do it anyway with the current charges. And that's I think that's what I'd ask for. I don't know if any other special conditions are necessary. I do know that he needs to get back to work, obviously not in a law enforcement capacity, to continue to pay his mortgage that he's had for the past 24 years. And so I'm asking for a $15,000 bond, Judge. And if the court has any questions, I'm happy to answer it.
Alrighty, ADA Thomas.
Your Honor, as a law enforcement officer, when this happened, this defendant was held to a higher standard by the community as a whole and his agency in particular. He was acting in a marked patrol vehicle, uniformed, when this incident happened. This wasn't an accident. And to say that it was bad judgment would probably be an understatement to the maximum. Two things that defense counsel said that kind of stuck with me, and I made a point to write them down. One of them was a mention of that a single moment or a single act does not define your character. But I would contend that a single moment, a single act can truly expose you for what you really are. Maybe it does, that single time, show the world what's really going on. This man violated his oath of office, but for his behavior, it could be argued that two people would still be with us on this earth. He was entrusted with the community's, he was entrusted by the community to safeguard their property, to safeguard our streets, to safeguard our lives. In this particular situation, not only was he the precipitating factor for the accident itself, but he didn't even bother to call to get these people some help. He didn't bother to file a report to indicate that something happened. And this is based on the testimony of the trooper, which the court heard on Wednesday. He didn't even bother to let someone know, even make an anonymous call to let somebody know that car had, in fact, wrecked. And then he went to the extra step to try to conceal the video that was recorded as a result of the unauthorized chase. Does a person's character manifest in one act? Based on the trooper's testimony, perhaps it did. And based on what we now know of former Officer Smith's behavior, state will contend that he is a significant threat or danger to the community. That he is a significant risk of perhaps committing an additional felony in the future.
This is where the prosecution lands its heaviest blow. ADA Thomas isn't holding back, calling Smith's behavior not an accident, but a revelation of who he truly is. Her argument cuts deep. A single act can expose your real character. That line hits hard. It challenges the entire defense narrative that Smith simply made a mistake. And when she reminds the court that there are no witnesses because they were left to die on the road, the emotional temperature spikes. The courtroom goes silent. This isn't just about legal standards anymore, it's about morality, empathy, and what it means to wear a badge.
Defense counsel mentioned one more thing that is kind of, I thought about it myself, but he actually brought it up. There is no witnesses to intimidate. That is the fifth Ayala factor, Your Honor. He's absolutely right. There are no witnesses because those witnesses were involved in an accident as a result of his behavior and were left to die on the side of that road. So yeah, he's absolutely correct. There are none. But that officer's patrol car, which told on him because it recorded the whole thing to the point where, as I mentioned previously, he attempted to conceal that video. But the trooper saw it. And as the court may recall, the trooper indicated upon watching that video, he noted that you can't hear anyone talking, but at the end, after the accident, you can hear somebody laughing. What does that say about this man's character? You just watched somebody have what turned out to be a fatal accident where 2 people died, and you're laughing. I would contend, again, he is a risk to the safety of the community. He is a risk of committing possibly an additional felony. State would be asking for no bond in this matter.
All right. So I have a couple of questions. And so, ADA Thomas, you can see that there is no prior criminal history?
Yes, ma'am. He was a sworn officer at the time of this incident.
And the date of this incident, what was the date of this incident?
August 17, Judge.
August?
That's correct. Yes, Your Honor.
And how long has he been in custody?
Not since that date, Your Honor, because investigation.
September 23rd, Judge, based on the jail records.
Yeah, and I'm pulling the booking sheet. I believe that's correct, Your Honor.
September 23rd.
Yes, ma'am.
And so, counsel, did you indicate that, I'm sure prior to being arrested, would he have employment? He probably does not have employment at this time?
Not right now. I think that he'll be able to obviously apply to other jobs and things of that nature. But not right now. Since the arrest, he's obviously not been employed because he was with that police department for so long. And so he would have to find new employment.
Your Honor, if the court recalls, I believe the trooper mentioned that during the course of his investigation, he found out that apparently that Mr. Smith had applied for employment somewhere at another agency.
Okay.
So the trooper took that to mean that he was no longer with College Park, but the actual termination, he did not know.
Righty. And did Mr. Smith turn himself in, or did they go get him? How did he come into custody?
Yeah, Judge, they didn't, surprisingly, they didn't call him or sort of let him know as being a law enforcement officer for so long. He would have turned himself in. They actually came to get him. He had no idea about the arrest warrant or anything. But everything else, sorry, go ahead, Judge.
This case is troubling.
Your Honor, if I may, regarding him turning himself in, that's my understanding of that is generally what happens. But the impression I got from the trooper is that they were so concerned with him actually concealing that video and absolutely not mentioning anything about this. And that might explain why they actually decided to go get him.
Well, I don't know if Your Honor's waiting for me to respond to that. We can speculate. I think Mr. Smith would have turned himself in if they would have just called him. I think he was very upset when I spoke with him that they did it like that because it caught him off guard. He had no idea about the arrest warrant. As far as the video, the testimony was that all he knows is that the major said that it took him a while to find it as if it were meant to conceal it. We don't know any other information. I wish we could have found out more about that, but we'll obviously get that information at the trial phase with discovery, which a lot of this stuff was like closing arguments for the trial. But as for purposes of Ayala, I believe everything's met.
All right. And so, as counsel indicated, I must consider the Ayala factors. Whether Mr. Smith poses a significant risk of fleeing and not appearing, there's nothing to suggest that. Whether he is a threat or danger to any person or community or property at this time. I don't have any testimony or evidence that he would pose a threat to the community. Obviously, he's not in law enforcement anymore. So that alleviates that. Pose no significant risk of committing any felonies while pending trial. And so I can't imagine that's not an issue based on his criminal history, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. Being the fact that he doesn't work there anymore, I'm not sure how that could be possible as well. I did not hear any specifics about his financial resources other than he's not employed. I don't know if he have any other sources of income. I do have to take that into consideration.
Judge, I don't really have information as far as his financials. I wouldn't be able to give the court at this time, unless you'd like to hear from Mr. Smith. I have no problem with him explaining to the court his financial position with regards to that aspect only. In order to determine a reasonable bond, I have no problem with that.
If you can just ask Mr. Smith, was his employment was the only source of income?
Ms. Smith, you want to answer that question, but I think they have to unmute you first.
Jail. Jail, y'all able to unmute?
It's unmuted now, ma'am.
Thank you.
Can you hear me?
Yes,
Okay. I said no, I'm currently not employed.
Mr. Rafus,
Yes.
ask your question.
Yeah, go ahead, Mr. Smith. You can tell the judge about what financial sources of income that you have, and if College Park Police Department was that your only source of income.
Yes, at the time it was my only source of income, but I do have ways of to get income, and I also do have money set to the side to pay bills for a few.
How much money do you have set aside? How much do you have in your account?
Few $1,000.
Okay.
All right. So, again, this is a troubling case as we have two individuals that are deceased based upon some actions that are alleged in these warrants. But I have to go back to the purpose of a bond is, number one, to ensure that the defendant appears in court to answer to the charges and to protect the public. So for public safety reasons, if that person is released from jail while they are pending, while the case is pending. I see, I think that the allegations are troubling, to say the least. But I think that I am obligated to set a bond in this case based upon the IOLA factors. The issue is going to be the amount. And the conditions that I impose. Of course, the defense has already agreed that Mr. Smith will not and cannot apply or work for any law enforcement agency in any law enforcement capacity at all. We know that. And I'm not sure, other than some sort of home confinement, other than work, church, and court, what other conditions could be imposed. And so I do want some language in the bond where if Mr. Smith is able to make, or when Mr. Smith is able to make bond, he is to remain in the confinements of his home unless he is going to work. Doctor appointments, court. Mr. Smith, if at any point you are stopped by police, if you have any contact with law enforcement, if law enforcement gets information that you are not inside your home and not doing one of the things that I've indicated, then you could be rearrested and placed back in jail. You understand that?
Yes, Your Honor.
88 Thomas, are there any, before I provide the bond amount, are there any other conditions that you would want to see on this bond order?
I'd like for him not to be driving, no driving, Your Honor.
How will he get to work?
Unless for the purposes that the court just outlined.
I don't know if we can. I think the staying at home encompasses that, because he shouldn't be, if he's not going to work, he shouldn't be out anyway, so he wouldn't be out driving. So I think we got that covered under he may only leave the residence. And so I don't want to put his address on YouTube, but when you compose that, Attorney Rafus, I would like to have that information in there. And also, without saying names, does he reside alone or does he reside with a family?
Alone, Your Honor.
I'm sorry?
Alone.
Okay, nobody else resides in the home?
No.
All right. This is a tough one. I did consider all of the character evidence that is presented on a vehicular homicide. And do you know, 88 Thomas, why we only have one vehicular
The other
homicide?
counts always have bond, Judge.
No, but I thought there were two people in the car.
There were, Your Honor, and I'm not sure why they only charged it with the one vehicular. However, I'm sure that'll be something that will be considered as the case is being prepared for indictment.
Okay. I am going to set a bond. I'm going to set that bond at $80,000.
Thank you, Your Honor.
So I'm going to leave the remaining charges as they are. I'm going to set this bond at $80,000 with the conditions is that he is to be confined to his home and only leave for the purpose of work, going to the doctor, going to court, going to work. That's the order of the court.
Judge, one thing, if I may, on the confinement issue, the exceptions to the confinement, I have court, doctor visits, and work, obviously. I'd ask for attorney visits. For
Attorney
him to be
visits,
able to-
yes.
I'd ask
And
for
I always
church.
add church.
Okay. And then the other thing I'd ask for that sometimes becomes problematic in my experience, when you have those few exceptions, is just to be able to go to the grocery store to get his groceries, to be able to eat and have some supplies at the house while he's there on home confinement.
They have Walmart, Instacart.
Even if it's something just like, once a week on the way home from work or whatever, can stop at the grocery store to get your week's worth of groceries. That would be very helpful. I do know from experience, because I tell my wife all the time, that those Instacart and stuff like that gets very expensive. The surcharges and everything that they add on.
Totally agree. ADA Thomas, what's your position on that?
Yeah, I use my personal preference is Amazon, and I think that there are options rather than stopping at a grocery store. You have Instacart, you have Kroger. My mom uses that when she's a senior citizen, and I haven't experienced any extra costs for that. I'm not sure what services you use, Mr. Rafus, but I tend to agree that he can have food delivered.
Or a family member. I want him to understand, and I want the bond to be that he is to be at home.
As the hearing wraps up, one thing becomes clear: this case is about trust, tragedy, and the thin line between duty and ego. Donnie Smith's defense argues that years of honorable service deserve leniency. The prosecution, however, insists that no badge can shield someone from accountability when lives are lost. Whether Smith walks free on bond or remains behind bars, this case will echo through every police department in Georgia as a reminder that authority doesn't exempt responsibility. So what do you think? Should a veteran officer get a second chance, or does justice demand zero tolerance? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.